All right, good morning. We're here in general and housing on another fine gray day to consider. We're still calling this H391 for the time being, though today we may shift it, give it a new number or a new name. But this is an act related to creating an eviction diversion program. When we last talked to Rachel Seelig from the Vermont Legal Aid, Jean Murray, Sandrine Kibwe, and Angela Zakowski, they went off and did some work on Friday afternoon.
Yes.
And the work that you did is being incorporated into a draft we're going to see in a few minutes. But if you could give us a review of what your conversations were like on behalf of the group. I mean, I know you can't speak for everybody, but individually, but if you could just talk about what the language that you're proposing, what it represents, that would be great.
For the record, my name is Rachel Seelig. I am Director of the Disability Law Project at Vermont Legal Aid, as well as our staff attorney for government relations. Wish I could say that faster for you. So we had a really good conversation after we were here and kind of highlighted a couple areas of ongoing disagreement for you. And so we agreed on a couple of different changes that we think can resolve those areas of disagreement pretty successfully. And as your chair said, you'll see those in writing shortly. But to go over them briefly, one of the changes that we agreed on was that there shouldn't be a limit to when landlords and tenants can access the Office of Rental Housing Stabilization Services. So, and that should be something that courts are kind of affirmatively encouraged to refer folks to if a case does get to court. So we are proposing changing the language so that there's not a stopping point of summons and complaint as when that office is available. And that it's really available at any time, including through court referral. The second big change that we had here was to reflect kind of some of what Sandrine talked about last week in terms of the cost of adding this to the responsibilities of CBOEO. And so I believe the proposal, and Sandrine's here, so she can correct me if I got this wrong, is to appropriate $400,000, which would allow 3 resource specialists rather than the 2 I thought would be enough. They really think it should be 3, as well as a part-time supervisor. And then the third piece in terms of the Office of Rental Housing Stability Services that we are proposing here is that we have agreed that we would drop seeking the requirement to include information about the office in the notice to quit. We think that we can really address making sure that judges feel like they have the flexibility to reset cases if that's the point at which landlords and tenants learn about the Office of Rental Housing Stabilization Services, or whatever we end up calling it, through the civil rules, that we can make sure judges feel like they have that flexibility to say, you know what, you've got 30 days to go to the office, see what you're screened and eligible for, and get those and come back to us and report. So given that, Vermont Legal Aid was willing to pull that out of the notice, which I think resolved the concern for the Landlords Association about the jurisdictional nature of the notice to quit. And then the area of disagreement on the rental arrears assistance program had been about the scope of what cases need to be dismissed if you get rental arrears. And we do have agreement now that any cases that are non-payment and no cause will be dismissed, whether they're 2 separate cases, which really shouldn't be happening, but does sometimes happen, or they're both within one case. But if there's a no cause case that's not yet ripe, that would not necessarily have to be eliminated. However, we would want to make sure that there is, and we think that the language we have already would create authority for the Vermont State Housing Authority to get that information about whether there is a no cause notice to quit that isn't ripe yet, so it can't be brought to court, but it's out there because that would impact kind of how useful those funds would be in preventing eviction. So we think that's a really good compromise position that we'll know it's out there, that can be part of the calculus in terms of what is available. And again, can still lead to things like mediation of issues that the landlord or tenant are having through the mediation program, even if that notice isn't ripe yet. So those are our big changes. I did at the end of the day yesterday get some additional suggestions from Sandrine that just add a couple of pieces to the screening that they would want to be doing in terms of housing, education, and skill building and other resources as needed. And really kind of laying out kind of what we've talked about in terms of what this office would do in better language than I came up with, that is not just about telling people where to go, but providing support and follow-up services and working with partner organizations to ensure that effective participation with identified programs. So I think none of that is going to be really controversial language because it just kind of fleshes out what we've talked about already. And those are the updates that we have for you all.
Questions for Rachel?
So a lot of what you just told us is fairly technical.
Yeah, it is.
And how much of that is included in the bill as opposed to the framework that you all needed to be comfortable with?
So the pieces that would be included in the bill are the scope of time that landlords and tenants can access the office, the amount of money that would need to be appropriated to CVOEO, and we would pull out of the bill the requirement about the notice to quit, including the language on the rental arrears. So that's currently in the bill, that would come out. And then there would be a small language modification in terms of the scope of dismissal in the rent arrears fund section.
Thank you so much for doing that
Yeah.
work and reaching that agreement.
Absolutely. Certainly what our goal is to make this work for everyone so that we can put these services in place.
And I just do want to point out that Angela Zakowski is unable to be here today. I heard that she is out of the country.
Oh.
School vacation.
Lucky her.
School vacation. I think that could be Canada, couldn't it?
Yes.
I don't know what out of the country means, but the information, while thank you for reflecting the group thing.
Yeah.
I mean, she will also, when we have this draft ready to go, she'll review it and let us know just part of the totality of the agreement. So I don't know where David just ran off to, but questions. While I invited everybody to be quote unquote in the room, so folks are here to answer questions if we have scattershot questions, especially when we have a chance to review the changes when David comes back. So while I have folks here, I guess I'll start with Sandrine. Thank you again for helping to create this programming. When David comes, we'll just need to make sure that we've got the language right based on what's been shared. The question, or I guess just the restatement, I just want to make sure we understand that CVOEO's role in this rental stabilization services would be to kind of fit in with what you do already in terms of statewide access to landlords and tenants. And just wanted, if you could just let us know that this reflects what you're, I mean, I'm taking Rachel's word at face value, of course, but I just wanted to get your thoughts on how you envision the this particular program for you.
Yes, thank you for having me again, and thank you for the question. As I said on Friday, but this is not unknown to us. This will amplify actually the services that we are providing actually right now. At this point here, the services that we provide through our hotline and follow-up services actually is based on the caller calling us with some issues that they have, either with the tenant, with their tenancy, with some issues with their landlord, or even to know what their rights and responsibilities are, depending on what the situation is. This office will actually, like I said, amplify it fully. Not only will have the opportunity to speak to tenants and to provide them with the support that they need in connecting with those services, but we also will connect them and support them with the connections, working with the partners into participating further. It's not only going to be just referral and information sharing. It will be connection and ensured participation to this program, especially when it comes to education and skill building necessary for their success, necessary for them to actually come out of the crisis. So this amplification is definitely needed. It's a great opportunity for us. It does enrich the services that we are providing right now, and frankly, it makes sense, at least to us, to have it at CVOEO, considering what we do.
Right, and just to just to get a clarification, when we say services, again, you're not necessarily providing the other mental health services or other tenant sustainability services. This is about, this particular piece of your work is to get people to the services they need. You called it a soft handoff, or someone called it a warm handoff last week. And I just, again, I'm just trying to nail this down for us, because I don't want to make an assumption that CVOEO is a one-stop shop for everything that's related to evictions and rental stabilization, but that this is an important piece that fits in with the others.
Yes, warm handoff. Yes, and to be even more detailed, of a warm handoff, if somebody calls you, somebody called the office, state the issue, we assess the situation, we actually look at the resources that are available, and we connect them to those services. But it's not one-stop shop as you explained it, because we cannot resolve all the issues, within CVOEO. The connection and building that connection is what is the primary role of the office.
Rachel.
Well, another way to think about it, for those who aren't kind of already familiar, is thinking about it as like a hub, right? Like,
yes.
This is where everybody's going to come in,
yes.
And not everything is necessarily physically in the hub.
Correct.
Their team knows all of those different service providers and spokes and resources and that sort of thing. And so then they can go out to those community partners and know what their screening guidelines are and help people not go to a door that's just going to get slammed shut, right? And that we think is one of the really incredibly important things, because people do get so demoralized when they're given like 6 places to go to, and then door after door after door just says, we actually can't help you, and you're out of luck. And then they don't get the help that they do need because they've given up after those first couple of doors.
Okay, David, Ron, did David email you at all?
Yes, he sent me something, asked me to take it back down, said he had to make a change to it.
Okay, but he hasn't contacted you since you walked out. Okay. Kathleen Burke, Vermont State Housing Authority in this amendment would be the recipient of the $2.5 million to, if we remember correctly, to kind of recreate the CARES Act version of the rental arrearage program. you had asked that there be some leeway in the language in order to be able to create the correct rules. Can you just give us some thoughts on where you are and does the, well, again, we can't say does this draft get it, but does the process so far get to where you need it to be in order to support this?
Sure. Good morning, and for the record, my name is Kathleen Burke. I'm the Executive Director of the Vermont State Housing Authority. And to your question, Chair Stevens, it does. I think that the proposed legislation provides appropriate guardrails, but also at the same time provides us with enough flexibility to be able to, in essence, recreate an earlier program, the Rural Housing Stabilization Program that you referenced that was extremely successful. Provided us with the flexibility, working with our partners to draft appropriate policy for Vermont. As Angela Zakowski has called it, it was a homegrown, Vermont-grown initiative, working with those folks that are most expert in understanding eviction and eviction prevention. And so that's what we intend to create. We also need to have the flexibility to respond to real-time situations that we can anticipate. And from our experience the last 3 years, you're never going to be able to contemplate the situations that you're confronted with. So I'm extremely pleased with the proposed legislation.
Yes.
Just clarification, so the policy that will develop to administer this program, that will be policy rather than rule?
That would be policy.
So that gives you the speed and flexibility.
Exactly.
And third piece of this is the representation pilot.
Yes. We don't have,
We've never had a representation pilot.
we had a very small representation pilot in Franklin County, but it was not a full representation
In
pilot.
fact, this was back.
Back before the pandemic.
eviction.
And that showed success just in that limited representation that was able to provide. So I think that gives us kind of, in addition to everything that we've learned over the pandemic, it's just one more piece of data that says that if we can provide people with full representation, we can help people stay in their homes and make sure that the rent gets paid.
So the overall piece in this for this amendment and for this program, basically the estimate of what the $2.5 million may be able to accomplish is upwards of 375 to 400 evictions through the payment of back rent. And the idea, and then the representation program, I believe you testified, could be participating in 250 eviction cases.
Yep.
Which may or may not have to do with non-payment. It's not solely about non-payment. Is that right?
That's right. And I'll turn to Jean for the kind of percent right now that we have in terms of between non-payment and no cause or for cause. Do you?
So the data that we have for the two counties that this pilot is proposed for, I was looking at it the other day, but about 38% of the evictions are filed for no cause. And then about 47% are filed for non-payment alone, and then there's a combination of the two. And so one of the things that you can do with full representation for no cause is you can negotiate a whole lot more. You can try to figure out what the problem is. You can see if parties would go to mediation. You can try to resolve the case with, Judge Torr was saying that she sees, because there are programs that Legal Services Vermont and Vermont Legal Aid have, so that we are helping people at the beginning of the case, how to answer, maybe to file a motion to dismiss, maybe to go to a rent escrow hearing, but she says she never sees them the lawyers for tenants at the end of the case where there's going to be a merits hearing or sometimes things don't get negotiated that could have been negotiated. I guess one of the things that I think about is that if I could do full representation for people, I could work on issues like accommodating discrimination. There's a lot of times tensions between landlords and tenants that arise out of a disability or some other thing. And those doesn't mean that it means that there's a way to figure out how to accommodate a disability without changing the basic nature of the tenancy. And with full representation, we would have more time to do that. So that's the idea of full representation. We think we would be able to prevent, well, in that group of 235, I think we'd be able to prevent additional half of that evictions. Not all of those cases right now end with a writ of possession, which is the final end where the tenant loses their housing. So it's a guess. I gotta say, it's a guess.
Yeah.
Sure.
That's why we would pilot,
We
right?
would
But
win,
then, right.
only get us more
Yeah.
with full representation.
So the idea, and then the idea of a pilot program, again, is a 2-year pilot program.
Yep.
Given the way that our cycle works anyway. But just to also, again, the report would be back telling us
How we're doing. And
how we're doing, right?
Yeah.
You
how
know,
we're doing, how the other pieces are playing into that, right? So one of the things we've offered to track is how many of those cases where we're offering full representation are going to BSHA for the rent arrears assistance. And if that's the reason that we're then able to resolve the eviction, or if it's something else, if it's one of the other resources from the Office of Rental Housing Stability Services, that is able to resolve it. So I think what we'll be able to track is how these 3 different approaches to eviction prevention play out when you put them all together. And then I think because VSHA is also excellent at data collection. And so they'll be able to track kind of what just their piece does in terms of eviction prevention. And I'm certainly happy to work with Sandrine to think about benchmarks that we could be including to understand what the impact is of their role in eviction prevention as well.
and my last question, just to clarify, how will you reach out to tenants for those services? Is it the same? Is it a similar way to what happened where you read that something's been filed and then you reach out to them? Or how will tenants,
Sure.
how will anybody know that
Yeah.
this program exists from on the street?
So what I put in, and I think I had a note for David on making sure that it worked the way that it should work. So in my world, in the Disability Law Project world, we are court appointed in certain cases, guardianships for people with developmental disabilities primarily. And so when a notice for that first hearing goes out, it also includes our court appointments. So we get told, there's this new case, you're the attorney for this person. And so then we get their information and we call them up and we say, we're your attorney for this case and here's what's going on. What we found in Jean's project over the last couple of years is that just sending a letter out to people doesn't get everyone saying, yes, I definitely want a lawyer, right? Like some people are just in a crisis place where maybe they're not opening that letter, or they open the letter, but they don't understand the letter. And so having the court do the appointment, the way that we do for court appointments in our project, the way that, they work in the world of the public defenders, that means that we are on the case. And then we need to, take that action to reach out and connect with those clients. And sometimes that means finding some service provider that they're connected with to help us make that contact. And sometimes it, is as easy as a phone call or an email or a letter. So that's kind of what we've proposed here, is that the court would actually do an appointment so that we're on the case.
Thank you.
Thank you.
David, please join us, please.
Did you have luck with that? Still not?
Is it lost in the intranet?
Floating around the world somewhere. Oh, good morning, David Hall, legislative council. Sorry,
You're a little bit.
did you? I've sent Ron outdated draft. Get where we're going. So what I can do is pull it up on the screen while it's waiting to be posted that way.
Thought I heard the ticky tack of the Western Union.
See this? Okay. So this document is what I sent to Ron, and it should be going up to your page. But so this is highlighted showing changes relative to the last time we looked at this together. It's based on, documentation and testimony that I've reviewed. Was not present personally for the conversations that have been going on. So if I've missed something or not done something correctly, I'm sure the stakeholders can tell me. There are 3 sections, and whether this is a H391 or anything else, it doesn't really matter right now. So section 1, you'll see here, I didn't have the sense that we're actually creating a brand new office, like there's a Champlain Valley Office of Economic Opportunity. Within DCF, there's the Office of Economic Opportunity. So it's really a program that CVOEO will be running, is my understanding. So the changes here reflect that. If that's not correct, you can tell me. But so A would be the creation and the purpose. And, obviously the point of legislation is to tell the world who does what. So here we're charging CVOEO to the duty to create and administer a rental housing stabilization services program to provide tenants and landlords with access to services and programs that assist in preserving a tenancy and avoid eviction. This includes eligibility screening, direct referral, and follow-up services. So for eligibility, a tenant or landlord is eligible to contact the office at any time prior to filing of a summons complaint for eviction or through court referral. And we're going to strike out that possible alternative language that was there previously. Decided it sounds like they've settled on open contact. Everybody comfortable with this so far? Okay, so screening, the office shall employ resource specialists. So this used to say two. I don't know that you need to prescribe the number or really the who. You'll see later there is an appropriation. It says the money is gonna go to CVOEO to basically to administer this program. So how they deploy those resources, they have the flexibility, right? So we'll just say for now, the office, and here we mean CVOEO, shall employ resource specialists who shall assess landlords and tenants for availability and eligibility for statewide or local assistance. Most of the things they would do are the same, all these other programs. There are a couple of new ones that I just received this morning. You can tell me if these are appropriate, but they are housing, education, and skills building programs and other available housing resources as needed. So it's really the full collection of the things that are available. Repair funds, rental arrears, HOP program, VHIP, subsidies, economic service programs, legal assistance, mediation, housing, education, skill building programs, other appropriate resources. Everybody okay with that? All right. So for referral, it says the office shall, it could say under the program, the office shall, it's the same thing. The point is what they're gonna do for referral is assist callers in contacting organizations that operate these programs and services and provide support and follow-up services and work with partner organizations to ensure effective participation in these programs and services. And as I mentioned, the appropriation would be $400,000 general fund, so it would flow through DCF, OEO, as a sub-grant to CVOEO to administer this services program pursuant to this section.
Which is standard.
It's fairly standard. There's lots of ways that we do this, as we talked about now ad nauseum. Typically, appropriations likes to see a state entity or instrumentality receive the funding, but if it's going to go to an intended recipient further down the chain, we set it up as a sub-grant. Everybody good so far?
Thank you.
All right.
And actually, before we get to section 2, Sandrine, does this represent what you anticipated signing up for?
Yes.
Thank you. Okay, section 2.
All right, so now we switch gears to tenant representation pilot. So again, who does what? Here in A, Vermont Legal Aid shall create a tenant representation pilot program to provide for representation to tenants in Lamoille and Windsor County for 2 years through appointment of counsel on filing of a summons complaint for eviction and to determine the impact of representation on the issuance of writs of possession, homelessness prevention. So tenant eligibility, everybody can check my language here, but I'm charging now the court shall appoint counsel to represent a residential tenant in Lamoille and Windsor County who has served with a summons complaint in an ejectment action and meets the following criteria.
And ejectment is synonymous for eviction.
Yes. Any questions? This is all unchanged until. Have we been through CD together? I think we have, or you have. And the report language is the same, interim, final.
No, it's existing language. I just wanted to check in on line 12 of that same page, page 3. It's 120% AMI. I'm assuming that means statewide AMI, and this isn't going to be differentiated by county. But it kind of seems like that's just like a ambiguity that's baked into a lot of our language that kind of allows people to choose the higher. I would love to see us just change this language to like state AMI at some point, because I think that ambiguity isn't helpful that I can see. It just seems like everybody would always take the higher number. I guess not in Chittenden County, but, and maybe that's the reason. Maybe it's like you want to be able to take the Chittenden County one if it's higher than the state if you happen to be in Chittenden County. I don't know. It's just this use of AMI in this kind of imprecise way is a little frustrating to just see baked in again and again. Just wanted to mention that. I'd love to see us be able to just show a little more clarity to the statute.
I think, I mean, my first stab at that is at least in this particular program, accepting, seeing your point clearly, but because this program is right now is scheduled to be in Lamoille and Windsor County, I would assume that it would be for those two counties, but
That's exactly right. Both Lamoille and Windsor counties are on the statewide AMI, so they're not heightened like Chittenden County, just because of where they are. So the two counties that we chose are that statewide number. We wouldn't be able to go to the Chittenden County number because we're not piloting this in Chittenden County.
But when you do Lamoille, what's the other county?
Lamoille and Windsor. They have the
Lamoille and
same-
Windsor have their own regional AMIs, is that correct?
They are both in the same category of AMI. They have the same AMI in both those counties.
And is there any AMI that's coded to those counties that's different from the state, or are they exactly the same?
They're the same. Yes. So if you look at your AMI chart, you'll see that there are a couple counties that are higher, but most counties are the same. And Lamoille and Windsor are both in that kind of balance of the state is one way to think about it. AMIs.
It's just on here, they're showing us two different amounts. Those two counties have different AMIs. And that's, I guess, kind of part of my point. It's just that, like, if we're just using the statewide AMI for all the counties that have their own, it's just to have this chart with all these differentiated numbers that we never use is annoying. That's all I'm saying. Because those two counties do have different AMIs. It's just that we don't use the county AMIs. We're always using the state AMI unless we're in a county where the county AMI is higher. It's just a kind of, yeah, it's just, I just wanted to call it out because it's something that I find confusing as a legislator.
If you wanted it to say the statewide AMI, I don't think we would have a problem with that because that's what we were.
What you're going to use. Yeah, and that's my understanding. I certainly don't want to change the program. I'm just calling it out because it's an area, I know it's existing law. It's just, or it's not something that's new in this draft at least. Anyway, that's it. It's just a thought.
so is there such a number as 120% of statewide area median income?
Yeah, so I think.
We don't need to know the number, but
But yes,
is
there
that a
is.
legitimate phrase?
Yes.
Okay, Caleb, is that something you'd like to just see as a?
Yeah, I would like it for the sake of clarity so that somebody reading this bill knows what we're talking about. And if they go to a chart like this, for example, they're not confused as to what those levels are. So yes, I would recommend that would be clearer language.
Okay. And again, this is going to be, household income is going to still have differentials between 2 or 3 or 4 people in the household.
So let me just be certain. So you don't want the county specific, you want a statewide number?
Well, I think if you put in the word statewide between of and area, it would accomplish it.
On line 12.
On line 12, I think if you just said 120% of statewide AMI,
I guess that's my question. Is there such a thing? Like,
there is such a,
there's an average
Yeah.
number for the
yes,
state?
and that's what is generally used, right?
It's generally used except in
Except
the
Chittenden
counties where it's higher.
Right.
Yes.
But yes, there is a statewide AMI for sure. And that's basically what's being coded off of. And that's why we're treating these two counties the same, even though they have different AMIs. We're saying, well, they're both under the state, so they're the same. But then there's this other reference where they're not the same. So it's just a clarity thing.
So if it's statewide, it's still called area median income? That's what I
The area of the state. It's confusing. It's confusing.
We're supposed to be done.
Can you just pin that, then let's just keep rolling through, please.
It's not super consequential to me. I'm in support of it either way. It's just something that I've noticed this session that I think might be helpful to recalibrate.
This is all, the rest of this is all the same. Down at the bottom of 4, it's still appropriation to AHS, subgrant to legal aids. Beginning of the first. So that's it for section 2. Anybody okay so far?
Yes.
Does it need a it has a sunset in it, right?
It says 2 years.
Okay, thank you.
So the rent arrears assistance fund. Probably to be consistent here in 3A, should charge this to VSHA. Did not do that in this one.
Where is that? Sorry?
Just an A, as I did above, as long as.
So you said Vermont Legal Aid shall do this.
Right, so here it would say, Vermont State Housing Authority shall create and administer a rent arrears assistance fund to provide funding.
Sure.
Eligibility, they will establish eligibility guidelines, ensure a streamlined application process, certification of past due rent, risk of eviction, will address eligibility, sustainability, referral. Funds available is the same, only necessary to cure, could include costs and fees, first come, first serve, eligible tenants until it runs out of money. Authority will create the application, certification, assistance to complete it. They'll have guidelines in the process, ensure prompt action. Don't have any changes in E. So the new piece really is down at the bottom of 7, dismissal. The authority shall adopt guidelines for disbursement to ensure the complaints based on non-payment of rent and complaints for no cause are dismissed, whether there's a single or multiple pending complaints. I did have a question here because this talks about there being the possibility of multiple complaints and for different bases, which I understand, but then the note, this paper that I received, that you want to address through guidelines requirement that landlords disclose as part of the certification process any no-cause notices to quit that are not yet right, and so not part of the case before the court, which can have implications on housing instability. So there seems to be a disconnect between the goal, which is to make sure we're addressing all the problems, but this is really limited to complaints, which to me would be complaints that have been filed. Which means there may be things that are preceding a complaint that you want to countenance.
Right, so we wouldn't put that in the statute.
Okay.
But when Kathleen's organization does their guidelines and does their request for information from the landlord, one of the things they would ask for is, do you have any pending notices to quit that have not yet become a summons? So I don't think we need language in there for that. It was more of a note to you and to Tom, or to Chair Stevens on kind of our thought process about why we were agreeing to that language.
Everybody's okay with the way 3 is written, or?
Yes.
You don't have to try for commit now, just as long as I got a list going here, things I need to fix, that's.
I'll cancel the tattoo.
Fair enough. And then that's really it, the bottom of 8 on the appropriation, so it's 2.5 million to VSHA to create and administer the fine pursuant to this section, so that's how we'll use the money. Any questions on section 3? All right.
Thank you for that. Um, So committee, I'm gonna wanna let this steep for a little while. We need to give time for Angela Zakowski to respond to this. And we have this on our agenda for tomorrow for discussion, markup, and possible vote. Yeah, this would operate as an amendment to S100. There's also a possibility of adding, we're going to hear testimony today and have an amendment to share this afternoon on H184, based on H184, which is what we hope is a solution to an issue that was raised with H184 about the lead removal certification versus licensure versus insurance. So we'll be taking testimony on that this afternoon. Any further, and that would be, well, that would be the package I think that we would put together as an amendment. We still need to talk about H21 from yesterday and make a decision on that. Maybe we can have a conversation today about what we thought about what we heard. I missed half of the testimony myself, but what it would take in order to either do that bill as a standalone, which means that if we do it as a standalone, then it would, and it passed the House, it would summer over in the Senate, would be taken up next year in the Senate. If we we could consider it as a further amendment to this amendment here. It's germane. So, or in my opinion, it's germane. I would leave full decision on that to the clerk if it were questioned.
So I don't want to presuppose any path, but if you are going to amend something like S100, which I assume you're not gonna retake possession of, then the amendment will have to be an individual amendment by one or more sponsors versus a bill that you have in your possession moving from the committee. So just, when I'm writing that, it would,
And so the question for us, committee, would be if we agree on the amendment as if it were a bill, then we would offer it as a committee amendment. Does that make sense? I want to treat this as a bill until we're done talking about it. This is how I'm used to building an omnibus bill, is just putting pieces that fit together like this. That would be the process for this, would be to say, do we agree, does this committee agree on what we're proposing here with the eviction diversion program in particular, but then with these other amendments as well? If we don't agree on pieces of the amendment, then we won't, I wouldn't necessarily want to include those in a committee amendment if people didn't support it.
I'm a little confused now. So David, when you say an individual amendment as opposed to a committee amendment, that would be following amendment is offered by and naming right members. Support it.
yeah, if you're proposing to amend something that's already left this committee's possession, then it would say representatives Chestnut, Gingerman, Stevens, whoever else, the list of people who are actually sponsoring it. Propose that the House recommend to the Senate, or recommend that the House propose to the Senate that the bill as amended by House General and Energy and Ways and Means and Appropriations be further amended as follows. Individual members proposing a further amendment. So just know that about the lead-in language. You wouldn't say the Committee on General Housing recommends, you would say the following individual members recommend. And the way that other committees do that, sometimes they just have one person do it. Sometimes they have everybody who wants to sign up. There's no right or wrong. I just want you to know procedurally why it would look different if you choose to go that path.
Right, any further questions on this bill at this time? I mean, are people generally supportive of what we're talking about here? And you know, we still need to go, you know, do our own walkthrough or talk through of each of the sections and see if there's beyond what has been presented by stakeholders and by David. So, and that's scheduled for tomorrow.
I think I'm just gonna chat with a few landlords in my area, and see where they're at.
And make sure when you do, when you just in general, also add in that we're hopefully solving the lead problem.
Well, not right here, but
What's that?
double not right here.
Not as part of this program, but just possibly as part of this amendment. But yes, please do contact us. All right, committee, so coming up at 10:30, thank you, David. Coming up at 10:30, we're going to start witness testimony on 103 again, which is the discrimination bill. And this is specifically at 10:30, we're going to hear from Heather Lynn, who was recommended to us by the School Boards Association. And then we're going to hear from 3 individuals who have lived experience, who want to share their thoughts about S103. So let's take a break now, and we'll meet back here at 10:30 or 10:25, or just let's shoot for 10:30, please, because we only have the attorney for about 15 minutes.